Judge Andrew Mickus on behalf of Ms. Owens, P76268. Ms. Owens would waive any objections to appearing via video today as well, Your Honor.
Okay. All right, did you speak with Mr. Zick this morning?
I did, yes, Your Honor. I think we've reached a mutually agreeable resolution to the matter. Ms. Owens is going to be entering a plea of guilty to one of the matters, and the court will be dismissing, and Mr. Zick will be dismissing the other matter. We didn't get specifics as to case numbers, but they are essentially identical. She would agree to any restitution amount. He did not have a figure before him. I estimate that that figure is going to be 0, because I believe all of the items were recovered in both cases at the time of the arrest. So I do anticipate that. But in the chance that I'm wrong and there is restitution, she is able to pay that today.
Are you pleading guilty of your own free will?
Yes, ma'am.
And Mr. Zick, I see you're back on this. Is there a preference for the people on which matter she should plea on?
No
I'm
preference.
just gonna plead. Okay, all right. So ma'am, back on, how do you plead to the charge of larceny?
Guilty.
Were you in the city of Taylor on January 31st of 2023?
Yes, ma'am.
And when you were in the city, did you go to Walmart?
I did, Your Honor.
And when you were at Walmart, ma'am, did you take some merchandise that wasn't yours?
Yes, sir.
Your Honor, I think she's stalling just because there was an attempt to do so, but because she didn't leave with the items. I did discuss with her the legal nuances between those, and that there really isn't one. So, JC, do you understand the question? She's asking if you attempted to take any items for sale.
Attempted, yeah.
All right. Where was she stopped? Parking lot or as she was exiting the building?
Before exiting the building.
Or as you walking out of the building, Miss Owens?
I was going towards the door.
I think she had just left the self-checkout area and was heading towards the door when store security stopped her and initiated.
And were there items that you didn't pay for when you went through self-checkout?
I mean, I don't know how to answer that. Honestly, Your Honor, I left the cart. I walked away from it. I don't know how to. And then the other one was,
Hang on, JC.
Wait, so Miss Owens, did you put property in your cart or in a bag that you didn't intend on paying for?
All right. This one is a masterclass in how to completely implode your own plea deal in real time. We've got Miss Owens, who starts by saying she's guilty, then immediately starts backpedaling, then contradicts herself, then tries to rewrite the facts, all while standing in front of a judge who has clearly seen this movie before. And here's the kicker. This isn't her first offense. The judge even points out she has multiple prior larceny convictions. So when someone with a record like that starts playing word games about intent, you can almost feel the patience draining out of the room. Watch how quickly this turns from routine plea hearing to full courtroom detonation. And pay attention to the judge's tone, because this isn't just frustration. This is a judge who believes someone is trying to manipulate the system mid-sentence.
Right, yes, I can't accept the plea, then we'll get a jury trial date.
Your Honor, I'm guilty.
Your Honor,
no, you're not guilty. Miss Owens, you've been through this before. You've got a ton of larceny convictions, right? This isn't your first rodeo. And ma'am, you're not required to enter a plea of guilty. But if you think you're going to sit here, I'm talking. If you think you're going to sit here and tell me that you didn't do anything wrong and think I'm going to accept your plea, you're sadly mistaken. I'm happy to have a jury trial. I like nothing more than a jury trial. You either want to accept a plea or you don't, and you're either going to be honest to this court and accept responsibility or you're not. It's that simple. And if you cannot lay a factual basis for what you did that makes you guilty of this charge, I will see you on your trial date. Are we clear, Miss Owens?
Yes, Your Honor.
So what do you think you did, Miss Owens, that makes you guilty of larceny?
Your Honor, the first offense, I didn't scan an item, and honestly, it wasn't to steal the item. I tried to pay for the item.
All right, so that's a not guilty plea. So, okay, we're gonna just go ahead and set these both for jury trial.
I did intend to. So, I mean, yes, I'm guilty on the second. Yes.
You accidentally didn't scan $250 worth of items?
No, I didn't say accidentally. There was a computer or something
No,
wrong
on
with
the first case, the allegation is that you stole 8 items worth $250. And you're telling me that was an accident?
Your Honor, I'm guilty.
Here is where everything starts to unravel. The judge asks a simple, legally required question. What did you do that makes you guilty? That's called laying a factual basis. You can't just say guilty. You have to admit conduct that satisfies the elements of the crime. And what does she do? She hedges. She dodges. She reframes. Suddenly, it's, I don't know how to answer that. That's a massive red flag in court. Because if you can't clearly admit the act, the judge legally cannot accept the plea. This isn't the judge being harsh. This is due process. And her attorney? You can almost hear him scrambling to...
We're going to jury trial. I'll set a jury trial date, and we'll see you on that date.
Your Honor, if I may have an opportunity briefly in a breakout room with my client.
I've had enough of your client, quite frankly, and the games she likes to play. She's lucky I didn't revoke her bond the first time, and now she wants to play with whether or not she's responsible of this or not. And no, I'm not comfortable taking a plea. She's made it clear she didn't do anything. We're all set. You'll get your jury trial date in the mail. We're all set, ma'am. I'll see you on your jury trial date. Thank you.
Ma'am, please.
You'll get notice in the mail.
I didn't.
Mr. Mikos, I'm sorry. I'm not tolerating your client and her nonsense. We'll set it for jury trial. If you talk her into taking a plea that she can reasonably put on the record without being full of nonsense, I'll consider it. But for now, we're going to trial. All right, we're back on the record. This is the People versus J.C. Owens.
Yes, thank you again, Judge Andrew Mikos, P76268 on behalf of Ms. Owens.
Ms. Owens, tell me your name.
J.C. Owens.
Ms. Owens, did we go over your constitutional rights a minute ago? Do you remember those rights?
Yes, ma'am.
Knowing all of that, how do you plead the larceny?
I plead guilty, Your Honor.
Back on January 31st of 2023, Ms. Owens, were you in the city of Taylor?
Yes, Your Honor.
Did you go to Walmart?
Yes, Your Honor.
I want you to tell me what you did.
Flips the switch. Notice the shift. The tone goes from procedural to personal accountability real fast. The judge makes it crystal clear. You either accept responsibility honestly or we go to trial. There's no middle ground. And when she references Owens' prior larceny convictions, that's not random. That's context. The court is signaling, we've been here before. A plea is a privilege, not a loophole. If the defendant appears to minimize or deny the act while pleading guilty, the judge is well within authority to reject it. This isn't anger for show. It's the court protecting the integrity of the record. Now here's where it gets really uncomfortable. 8 items, $250. And she suggests it was some kind of glitch or misunderstanding. Think about that. Self-checkout errors might explain 1 item, maybe 2. But 8 totaling $250? That's not a scanning hiccup. That's a credibility issue. And credibility is everything in court. The judge isn't arguing facts here. She's evaluating honesty. Once the court believes a defendant is playing semantics, trust evaporates instantly. And once that trust is gone, the option of a negotiated plea starts disappearing with.
I think I honestly, I don't remember what items exactly, Your Honor. I think they were just normal, like condoms and stuff. Toiletries, yeah.
Did you take them with the intent to deprive that Walmart of their property?
Yes, Your Honor.
And did you take those items and put them in a bag without scanning them at self-checkout?
Yes, Your Honor.
Are you satisfied, counsel?
I am satisfied, yes, Your Honor.
All right. I'm going to accept the plea as knowing and voluntarily given. The case ending in 230-962. That case will be dismissed per the plea.
When the judge says, "I've had enough," that's not just frustration, that's finality. She even mentions Owens was lucky her bond wasn't revoked earlier. That's serious. Bond revocation means jail pending trial. So this wasn't just a scolding, this was restraint. And when the defense attorney asks for a breakout room, the judge shuts it down. That's significant. Normally, courts allow a quick sidebar to clarify confusion. But here, the judge believes this isn't confusion. It's deliberate back-and-forth manipulation. That's why she refuses to entertain it further. Once a judge believes someone is playing games, the leash gets...
Meet with the probation department for a pre-sentence investigation. You're going to get notice of that in the mail.
Okay.
And you're going to meet with them. And I'm sorry, Mr. Mikos.
No, go ahead, Judge. I'm sorry.
Yeah, I think we need an evaluation. So you're going to meet with the probation department, Ms. Owens, and they're going to contact you for a pre-sentence interview. After that interview, we'll meet again for sentencing. Are you still on felony probation?
JC, are you still on probation with Judge Matthews? Yes.
Yeah.
Okay. All right. Well, I'm assuming a lot of things will likely run concurrent, but I want my probation department to at least look at it. And Mr. Mikos, I can't give you a sentencing date because I don't know how backed up they are on their PSIs.
I understand.
So it'll be a Wednesday and we'll get it out to you in the mail as soon as they meet with her.
Okay, we're probably talking a few weeks out.
At least, I think generally 3 to 4.
Okay.
And bond conditions will just continue until then.
I'll watch this carefully. We're back on the record. Rights are reread. Formalities repeated. This is essentially a reset button. The court is giving her one clean shot to do this properly. And this is important. Despite everything, the judge still allows the process to continue correctly. That shows professionalism. The court isn't punishing emotion. It's enforcing structure. And now the pressure is on. No more hedging. No more ambiguity. Just a direct question. What did you do that makes you guilty? This is the moment where either accountability happens or trial becomes inevitable. I intended to steal items without paying for them. 12 words. That's all it took. No loopholes. No computer glitch. No accidental scanning theory. Just intent. And legally, that's everything. Larceny requires intent to permanently deprive the owner of property. Once she says she intended to steal, the factual basis is complete. Notice how calm the courtroom feels now. Because clarity replaces chaos. It wasn't complicated. It wasn't impossible.